What's up, everybody? We are here with an update on the Kings Road house demolition. We did a video last week discussing it, what it looked like, what the pros and cons were for demolition, how we felt about it, how you felt about it in the comments. Some people agreed, some people disagreed. I think that's all fair game. And we were explaining it kind of from our perspective as a lawyer, thinking about the defendant's right to a fair trial. What if we want to do a jury view? Things like that. But as we always say on this channel, and as we talked about with Mark Eiglarsh, the lawyers handling the actual case, the people subject to the gag order, I will say, the lawyers, the agents, the experts, the people actually working on the case always know so much more than we do. And in this case, it is specifically true and highlighted by that gag order because they are not even allowed to disseminate information about what's going on in the case for the most part. So we have to trust that the lawyers know what they're doing, that they know what is best for the case and for their clients, the people they represent, whether it's the people of the state of Idaho or whether it's Brian Kohberger. They know best. They are focused. They know what's going on. They have information. They have discovery. They have witness statements. They have pictures and videos and recordings that we will probably never see because not all of it's going to come in. And even if it does come in, the trial might not be televised. So in an effort to fully understand that they know so much more than we do, our friend Sleuthy Goosey posted on Twitter, and a lot of you sent it to me, some emails from the attorneys on both sides. And they agree with how they think this demolition process should take place, if at all. So we're going to look at those emails today. Hit that like button if you haven't already, and please subscribe to our page as we continue to grow the community talking about this, understanding. And this is like a different angle and element, right? Because now we have the university involved in the criminal process. What should they have to do? Are they violating people's rights? Are they choosing publicity over what's best for the case or over a fair judicial process? Is that actually what is happening? So let's take a look at these emails together. All right, so let's take a look at these emails together. And before we actually bring them up, I want to show here courtesy. This is from Sleuthy Goosey, courtesy of by Mike Baker, emails between the prosecution and the defense regarding the demolition of the crime scene. Okay, so thank you, Sleuthy Goosey and Mike Baker, for posting these. Let's take a look at what they say. First thing we can notice here in any email is who wrote it. Bill Thompson, we know who that is, the prosecutor for Latah County in Idaho. This was sent back on April 6th, so a couple months ago. And it was sent to Kent Nelson, who works at the University of Idaho, as you can tell by his email address. Good afternoon, Kent. We have discussed this amongst ourselves and with the investigation leadership and have no objection to the University of Idaho proceeding as you outlined. Okay? So not just proceeding with the demolition, but proceeding as it was outlined by the University of Idaho. And not just the lawyers making the decision, but also the investigation leadership and investigation team who would potentially need to go back in, do more testing. What do we need to do? What do we need to keep? As you know, the court has already released the scene from law enforcement custody based on a stipulation of the parties. So the court has released it, not based on a court decision or something the court forced, but instead the court just agreeing to do what the parties stipulated to do. That's very common. If the parties agree to do something, the court's going to allow it for the most part, unless he feels like he needs to step in the interest of justice. The scene, and this is the highlighted part. I didn't highlight it. I don't know if Sleuthy Goosey did or somebody else. The scene has been substantially altered from its condition at the time of the homicides, including removal of relevant property and furnishings, removal of some structural items such as wallboard and flooring, and subjected to extensive chemical application, creating a potential health hazard. So a couple times I said things like, if it was oozing toxic material, then it would be okay to demolish it. Well, it seems like they're saying potentially could be oozing toxic material. So it would make sense to actually demolish it now and not wait. It's funny. I didn't expect that, but that's what it turned out to be. These are some of the reasons that we have concluded that a jury view would not be appropriate because it is not in, and I'm adding here, because it is not in substantially the same condition, they're saying, because of the testing, because of what was removed. If you remember back to the Murdoch case, the clothing was rendered useless because of all the testing. The raincoat was a different color. These kinds of chemical testing and things that's done to evidence sometimes render it useless for a jury to view, and it could actually do more harm than good, confusing the jury. So in this case, they think we're better off demolishing it. We're not going to use it for a jury view, according to the state. And usually the state's the one that wants the jury view. Not always, but usually. Please let us know if you have any questions, and thank you for working with the families. Bill, so they did work with the families, even though Shannon Gray said they talked to us, but they didn't really take into consideration what we wanted, and they're doing the exact opposite of what we want. So I can see it from this side. All right, here we go. Next, this is from Ann Taylor. We know who she is, representing Brian Kohberger, to the same Kent Nelson regarding 1122 King. Good evening. I'm writing to let you know that the defense has no objection to the university proceeding as it sees fit with the residents on King Road. Again, do what you want with it. It's your property. We don't need it anymore. Previously, the defense agreed to release the property. Upon communication with the university, we were asked to weigh in on the demolition of the premises. This sounds like an email she knows is going to be read by more than just Kent Nelson. We appreciate the accommodation of one final walkthrough. After the walkthrough, our team has discussed the demolition of the premises again and have no objection. Thank you, Ann Taylor. So what's interesting about this is they were granted one more walkthrough, and they did that walkthrough. And we talked about, what if there's something else? What if they want to do this? What if they want to do that? At this point, they're pushing towards a trial in October, and they should pretty much know what they want, what they don't want, what they need, what they don't need. Investigations have done chemical testing, walkthroughs, reconstruction, whatever it is they need to do. So they did one last walkthrough and felt like they've got enough. They've done what they need to do, and they have no objection. And again, she didn't just do it herself. She didn't just do it with her lawyers, but she also did it with the investigative team, the experts, the people that would do testing, the people that would say later, oh, you know, it would be nice if we could go back to the house one more time and see this or that, to see if we need to do any more testing. Well, at this point, it seems like everybody working the case on both sides who know what's going on, and as sad as it sounds, and it's not that I'm disagreeing with the victims or their families, their lawyers, but we know that they don't know as much as the investigation teams and lawyers on both sides know. So I think at this point, we have to trust that they don't need it anymore. Now, where that could change and where there could be a wrench in that is if they feel like they need it for the civil case, the potential civil case, I should say. And if they do feel like they need it for the potential civil case, then they need to file a motion with the court to block this and explain why they need to do testing or take pictures or reconstruct or whatever, and get a court order to stop this demolition. Outside that, I don't feel like just saying it publicly is going to do anything to stop it. The two parties agree. The judge agreed to release it. And now it's up to the University of Idaho. They reached out to both sides, and they reached out to the victims' families. Now, they didn't do what everybody wanted, so it seems, but they did at least reach out to everybody before making the decision to, now it seems like they are in the process of demolishing it. People have sent me some pictures. I should have put one up here. It looks like it's all boarded up and ready for demolition. But again, you guys tell me what you think. Do you think this makes it more likely to be fair and not create a fair trial issue later? Because the defense has agreed to it. And once the defense agrees to things and stipulates to things, they are assumed to have considered all the options and made the best decision for their client. And that's kind of where I feel like we are. And again, the fact that the whole team, the lawyers and the investigators did this together makes me feel more comfortable with it. And we have to trust that the lawyers most intimately involved in the case know what's going on and make the decisions that are best for that case and the client and people they represent. But I always want to hear from you in the comments, so let me know what you think and hit that like button on your way out. I appreciate everybody joining me, but for now, that's all I've got. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.